Really excited to welcome Dennis Debroeck to the stage here, as they say. Let me give you a little background on Dennis. He's a former senior partner at Fenwick and West. There's some really interesting things in his background. He's actually founded his own law firm that he ultimately sold. He was dubbed one of the best lawyers in America, which is, you got to talk about that. And then the one that's really great, he's considered a super lawyer in Northern California. That one you really got to talk about. So with that, I'll turn it over to Dennis. Dennis, thanks very much for being here.
Thank you, Greg. I appreciate it. The topic that Greg and I kind of came down to initially, I gave him all sorts of things on venture capital, vesting of founders, collecting the IP. But what he really wanted me to talk about was how do you deal with your lawyer? And so I kind of find it interesting that I'm in the capital section because most people think lawyers absorb the capital. And what I do, though, as I say, is keeping your eye on the prize at all times. The eye on the prize is that next round of financing, that exit. And I think that as a result of my background of 40 years of practicing law, it was alluded to already, I was a inside counsel for a while. I formed my own law firm, merged into a multinational firm, and 20-some years ago I became a partner at Fenwick and West. And in all those arenas, I was in a position of management, hiring, firing people, paying people. And so I think it gave me a great deal of empathy for the entrepreneur. Currently, I'm an advisor to entrepreneurs, but I have a new passion, which is I'm involved in some conservation and in board chair for Peninsula Open Space Trust. But when I got asked to do this by Ken, I kind of went to the next thing. This is part of my AA. This is Confessions of a Recovering Lawyer. After 40 years of doing that, it's hard to get out of the habits. And then what I look back on is how do lawyers collaboratively work with their clients and vice versa and not have this adversarial relationship that sometimes occurs. By the way, today I Googled what profession had the highest and lowest ratings. Lawyers are pretty far down, as you might expect, but I saw business executives were not much above it. So I chose 4 topics today to talk to you about. Choosing a counsel, I'm going to label that one the blind date. I met my wife on a blind date, so it does work. Then the next one is living with counsel, the privilege, so to speak, of counsel, and paying counsel. So working with lawyers, do I really have to? I mean, come on, what are they going to teach me? I'm going to have a theme here, which is you want to engage with your lawyer early on. And when I look back kind of the things that I've seen legally, and I reflect back on what Eric Stang said and what Ken Denman said, I realize that both of those two gentlemen reflect, I've seen almost everything. Startups, raw startups, failed startups, good, bad financing, spin-outs, you name it, board dynamics, etc. So a lot of times, though, the legal counsel is a counselor, not just a legal, but counseling boards, and certainly have had that experience. But when you first start to choose a lawyer, most of you go from a referral. I assume that's the largest percentage of how you found out somebody, and that's the way lawyers actually get most of their clients is by referral. But really, the question you want to ask a bit is, do I choose the lawyer or do I choose the law firm? And the answer to that is yes to both. And the harder one, though, is the law firm, because there's 2 elements in a law firm that you don't see behind the screen that can dramatically affect the power of that firm that you want to be presented to you and available to you. Because in some ways, you're hiring that law firm, not just because I'm the corporate lawyer, but they got a great IP group or another group. And so you got to understand behind the scenes, is it, 1, startup centric? Because if it's not, it's very hard. Let me take a step back. Appreciate the startups. Because I could walk in Fenwick and West, a startup client, down the hall to a patent partner who was only doing Google or Facebook or Apple, and they would take the time to talk to this little teeny client. That is not what you find in a lot of law firms. So they have to actually appreciate that startup practice. And I think as a result, You want a law firm that just doesn't bolt on a startup practice, but it permeates the firm. And much like the venture capitalists, to have success in a venture capital practice or a startup practice for a law firm, you have to have a lot of them. And Fenwick was, successful in having the work for a lot of them. But it took a lot that didn't succeed either. And that success, though, led to other practice groups getting their business also. So startup-centric. The next is cooperation. That means compensation. You don't know how partners are compensated, but too often in law firms, partners are compensated based upon eat what you kill. So I bring it in, and I throw it over my shoulder and have somebody else do the work, and I get all the compensation. That's not what you want. And I can tell you in practice, my wife was general counsel of a major company. Their primary outside law firm, she wanted a particular partner to work on a particular transaction, and that's when she ran into the buzzsaw reality of the compensation system of that law firm. Really wasn't incentivizing this particular partner to come work for her. The next question that you guys might not have, depending on the level of sophistication, is, are you my counsel? Who you counsel for? And you may have seen in engagement letters that it says, we represent the company, we don't represent the founder. And you go, well, I thought you were my lawyer. Well, there's litigation that's occurred, unfortunately, where people said, I'm your lawyer, but what we are is we're company counsel. And what does company mean? It's a metaphysical thing. I mean, who's the company? Well, it's the CEO and it's the board. But you got to keep that straight, because sometimes it's occurred where we're on your side, but it's not like we're representing you in your personal interests. But it doesn't mean we don't talk to you about your personal interests, but we aren't really like your lawyer counseling you on the exact avenue of what you should personally do. The next thing is law firm conflicts. And you go, should I even care about law firm conflicts? And there's two types. One is the business conflict, and the other is the legal. And the business conflict is, well, don't you represent, a lot of people in my industry? Do you represent my competitor? Do you represent, as a law firm, people that might acquire me? And generally, the law firms that are startup-centric, tech-centric are going to say yes. And you go, should I care about that? Well, I think you want, actually, your law firm to have domain experience. You want them to have industry experience. So you don't want them to be representing only you in the SaaS space and have no other experience whatsoever. So then you go, well, how does this play out in a merger? And ironically, and I can speak from at least Fenwick's point of view, and Ken was an example of that. Our firm did work for Apple. When Apple wanted to acquire Ken's company, we could get a waiver. And you have to have a waiver in a legal conflict. You can't be adverse to two clients without both of them waiving it. And often the big company will in fact waive the conflict, because it really is in everybody's interest, because the startup lawyer, the one that's been with you throughout, knows your personality, knows your business, knows your cap structure, and it creates a much more efficient transaction for us to be on the other side. And oh, by the way, general counsels for big companies proactively engage law firms to be able to conflict them out. So we've had firms that came to us that we had on a blacklist that we didn't ever represent because we didn't want to be adverse to them, because they were quite adverse in certain areas to our clients. One of which was Intel for a long time, because they were making investments and they were very strict on giving waivers. So we just said to our tax guys, you can't take that business. But as a result, though, of a lot of the general counsels conflicting people out, they're used to giving waivers. Okay, so the next one I think is living with your counsel. These are little vignettes of things that happened to me. I don't want to talk to you. You charge me. Well, you got to fix that, because you want to talk to your counsel ahead of time. You don't want to dump a transaction on them. So how do I do it? You attend board meetings for free. Almost all the major firms do that, and it's a good way of getting to know the people, the board members, the personality. So when the transaction hits, you know what's going on. Grab a cup of coffee off meter. The next one, though, is lawyers speak. And every single industry, every single profession has the way they speak. And so the client is coming in and explaining, I got this great idea, this great business. The lawyers are nodding their head, and before the client could even get it out, they go, "Oh, you know, the problem with that, has anybody had that ever happen to them?" Doesn't it drive you crazy? And I bet what you did is you kind of took a sidestep over here because he's trying to roadblock you here, and you tried to go around him. And he steps over here, and all of a sudden you got this chess game going back and forth. Nobody's taking a step back and saying, what are we trying to achieve? What's the landscape we're trying to achieve? I have to give you an insight. The reason lawyers say the problem with that was success in law school. That was success in passing the bar. It's spot the problem, it's spot the issue. So it's ingrained. I found myself doing it till a couple years in, and I didn't like it, and I consciously changed it. If I hear it now, it just drives me crazy. All right, the next one. But you're just an effing lawyer. I went over to a client. We've been trying for months, literally months, to do a commercial deal with a big company. And I said, you know, I just think we're down in the weeds. I'm changing A to B, they're changing B to A. Let's write a mission statement on the board of why we're doing this deal so when we get lost, we can look back up. 5 reasons they're doing the deal, 5 reasons we're doing the deal. And the client looked at me and says, but you're just a fucking lawyer. And I said, humor me. I won't charge you. And that was early in my career. I don't know where I got the gumption to do that, but he became a lifelong client. And unfortunately, there was really no deal to be had. What's the lesson? Take the time up front to do, and it's just like designing a product. What are your goals out of this transaction, and share them with lawyers ahead of time so that you don't get lost in the weeds. All right, what's the privilege of counsel? The privilege is the attorney-client privilege, and there's 3 takeaways here on that. What is it and why does it matter to me is the first one. Attorney-client privilege is when a lawyer is speaking to a client about a legal issue, that communication is privileged and can't be discovered in a litigation. That's the general principle. Well, how do I lose it? Well, sometimes you never get it. And that really goes to the second one, how do I get it? I'm in a boardroom of a public company. We're trying to have a hostile takeover, and we're giving advice on the board's fiduciary duties and what it can and can't be doing. And in the room are a host of non-clients, because it has to be legal advice to a client. So you risk losing it when you have in the PR people, the IR people from outside, the investment bankers, and so sometimes we ask them to leave. Also, the way you don't get it, and again, I can harken back to experience I had with Eric. I was being CC'd by 2 board members on a board that he was a chairman of. They were kind of arguing with each other over business issues, but by CCing me and putting down this other person, they thought they had a privilege. They don't have any privilege. It's CCing your lawyer does not make that seeking legal advice. And just putting me as a CC on an email just doesn't work it. So you go, how do I lose it then? As I said, you may not get it to begin with, but it can be waived. Attorney-client privilege can be waived. And I'm interviewing a CFO about a revenue recognition investigation we're doing. I represent the company. And unfortunately, lo and behold, say the CFO or something has done something not appropriate, and the ultimate litigation occurs, and it's the company's interest to waive the privilege so the discussion that I had with that person can be discovered effectively as a defense, so it can be waived. I think the more interesting thing that occurs with startups, though, and it's actually come into merger agreements in recent years, is I'm the target, I'm giving you advice, we get acquired by a big company, they own the assets now of the target. Oh, one of the assets is the attorney-client privilege. And there's a litigation with the shareholders of the target. They'll waive the privilege of what I told them. So a lot of good M&A lawyers right now try to preserve the attorney-client privilege not being somehow part of it or part of the document. So it's a little in the weeds, I know. Kind of interesting for lawyers. So now the fun part. You get to pay us. I I came up with this: is it a guesstimate, is it an estimate, or is it a fixed fee? What are you going to charge me? More and more firms, particularly we had a relationship with Cisco that they put us on a retainer to do all their M&A, and it was a quarterly retainer. And so we said, the world's coming to more fixed fees or more parameter-based pricing. And so we actually hired probably half a dozen cost accountants, went through hundreds of venture capital deals, hundreds of mergers, and hundreds of litigations, broke them down into types of transactions, such as it's a cash merger, it's a stock merger, et cetera. Broke it down into component parts, the term sheet, the documents, the offensive diligence, the defensive diligence, et cetera. And I could call up on a database, okay, I'm doing this kind of financing, this kind of deal, and I can get those parameters. And so it gave me a great way to give an estimate to clients. But there's a lot of variables that go into the legal fees, time being not a good one if things drag and drag and drag. And if clients want a fixed fee, a lot of GCs have told me that they find it okay for like your 34-act, attending board meetings, but routine things. But it really creates a challenging up front because you got to come in with a bunch of parameters in the deal. Okay, are we going to have SEC review? Is it going to be multiple reviews? Are we going to have a HSR? Are we going to have a shareholder vote? We're going to have litigation. All these parameters, and frankly, you can build them in. But a lot of times, I think it's really a better way to go back to it as an estimate, and based upon the history that you had with this database, to build expectations, because I think that's really the big part of it. Somebody else said the keep it simple, stupid approach versus bespoke or handcrafted. And I'm going to combine this one with the optimizing, just these two. When you optimize in a transaction, you're not necessarily keeping it simple. But I had, in the keep it simple, stupid approach, the context here I think is helpful of the people involved. We had a startup. They were seeking to hire as a founder, a professor. Clue one, obviously, a lot of professors have no sense about vesting and what's appropriate. Number two, he was Israeli and represented by his Israeli wife and his Israeli lawyer. And their style of negotiating is to kick the door down, step in, and that is already, you've acceded to that piece of property. And so as we kept negotiating with him, and as my entrepreneur CEO kept giving in to him, we kept rolling back all these changes into the documents for the other founders. And I kept saying, this is not down the middle of the fairway. This is not what the VCs want. And we did reverse a lot of that when the VCs came back in. It just wasn't what you saw as a commitment from the entrepreneurs. So the optimizing, my pet peeve on optimizing is tax lawyers, tax accountants. Whenever I've had a transaction that used to be driven by taxes, and it seems like we always lost sight of the business purpose. And if you ever hear a tax lawyer or a tax accountant say, whoa, this is really interesting, run away, it's really expensive. I experimented, I retired, I told you, last January. For 3 months, I was working with a good friend of mine who had been in private equity. They're trying to set up a startup that had Spanish founders, professors. Again, we had this whole thing with people not recognizing what's typical. But the private equity guys used to all sorts of cash flows and taxes, and he engaged a tax accounting firm that came up with this Rube Goldberg structure. We had a European holding company with a Spanish, and when we had the US holding company, we had exchangeable shares between the two of them. So if one got taken out, the other ones could exchange their shares. And I kept trying to figure out, why are we doing this? Oh, that's the best tax consequences for dividends to our Spanish founders. So literally, I got on the phone with the Spanish founders, with the tax guys. I said, okay, how long before we have a product? How long before we have sales? How long before we have profit? Oh, and then cash flow that we actually want to distribute versus reinvesting in the business. And in that continuum, isn't this the kind of company that would probably sell here? So we're optimizing for an event that's so problematic, and it was going to be so expensive. And I kept telling them that it was so expensive. But that's one of the things that you want good counsel with, that sees things that are a little bit down the middle of the road, usually what is typical. Not that they can't be creative, but that will save you money. I have a page break here because I had a whole bunch of other slides that initially I prepared that did with venture capital financing and vesting and other things. But again, as we decided that my capital piece should be a talent piece, I thought, but other than me taking all the money. So I hope this helps you figure out how to work with your lawyer a little bit better. It's a two-way street. Thanks.
Dennis, thanks so much.
Oh, sure. Sure. This is Silicon Valley Venture Capital Survey is something that Fenwick and West has been doing every quarter since the bubble burst. We used, when the bubble burst, I'd walk down the hall and go, what kind of liquidation preferences are you seeing now from the VCs? What kind of, and so what we did is we did a systematic, every single financing that's done every single quarter, not just by Fenwick and West, but in the whole Bay Area. It's a lot of work to digest them into the component parts of some of the terms that Eric was talking about, whether it's liquidation preferences, senior liquidation preferences, anti-dilution. So it gives you like a current, up-to-date, what are the current terms being used. This is online at Fenwick and West. It's also a handout. And I think we may have also one handout that is on patent strategy, which was a whole nother subject we're not going to talk about.
That's perfect. We have those for you if you want them. We can get them to you electronically, but thanks, Dennis, very much for that. It was terrific. Thanks. Oh, yeah. Hey, Ken.
Being a venture guy, then being a public company CEO, and then back in the venture world. And one of the things that was kind of amorphous through much of that time, until I started working with you, is, how do you manage that relationship? Or how would you suggest that the venture folks should manage that relationship where you move from just getting legal advice from your counsel to, walk in the right line to where you can also have that counsel be sort of a consigliere, can talk about business advice, and sort of navigate the line between the legal advice and the business advice. Because it was really frustrating for me often to, when I couldn't get them to cross that line with me, when I just really wanted to talk about the broader thought. Not just get the legal advice.
I think that's endemic in a lawyer. Everybody values what they know well. I think they're really good business lawyers. Let me just take a step back. I'm a little bit of a throwback in my practice because I start with companies and walked all the way through the IPO merger. And a lot of specialization has occurred, and people can drop in like they're the Marines hitting the beach and come and go. And I just think that it really causes a lot of problems because I was doing a merger where a great law firm, their relationship partner for this company, handed it over to a great M&A partner, but they had no chemistry with their CEO. And we were able to talk directly to the CEO almost in negotiations. So it's the investment. It's the investment of time that I think people won't have to do. And at least personally speaking, one of the questions you might ask when you go hire a lawyer, why do you get up in the morning and go to work? I think that was a question that was already asked. And for me, it's much more about the business and relationships. Now, you could say I was a frustrated businessman. I got 1% better on the law school exam than the business school exam, so that's history. But you just got to invest both ways. And the lawyer, honest to God, if you're talking about it on the venture side, they'll see a lot of benefits from it. They don't. It can't be a short-term mentality. It has to be a long-term mentality.
Perfect. Thanks a lot, Dennis. Appreciate that.